All right. Well, landlords, I am happy to join you for our I say face. I'm happy to join you for our YouTube live. I'm happy to see those of you who are logged on already. We are coming to you as we always do on Wednesday afternoon at 4 o'clock Houston time. For those of you who haven't joined yet, we're going to wait a few minutes before we get things really moving. But we're about to enter into today's topic, which happens to be let's see, where's my button? Here we go. What do you recommend for tenant screening? So I'm going to give you 4 tips on what I recommend to landlords having to do with tenant screening. These are basic things that all landlords should have in their arsenal when they are screening tenants. I don't know how many times I've talked to landlords about problems they're experiencing that very easily could have been resolved with some proper screening. So I'm hoping that by implementing these tactics and these methods of viewing problems before they ever occur, you're able to spare yourself not just time and money, but also the headache of having to deal with bad tenants or really bad situations created by improper planning. So hopefully you're going to get a ton out of this, and I'm hoping that you're able to add a few ideas. How's it going there? All right, James, I see you coming in. And, I see Alexander there. Good to see you. I see you've got a question there, Alexander. I appreciate that. I will definitely get to it. I do want to mention to everybody else who's watching live, I've got a set of questions that I've planned for, I've prepared answers for, and I get these ahead of time either through our newsletter or I get these through our Facebook group. And so I want to make sure that everybody is aware how to reach us on our newsletter. You're going to see along the bottom, the ticker there, you're going to see our phone number. You're also going to see our email address. If you are not on our newsletter, feel free to jump on and you'll get weekly updates from us, as well as an option to add your questions to the live. Whether you can watch it while I'm saying it or you watch the replay, I'm trying to make this as user-friendly as possible so that you can get your answers that way. And so getting on our newsletter is one way. The other way is to join our Facebook group. If you have property in the state of Texas, we have a Facebook group called Texas Landlords where we post this question and you can post, or we post our topic and you can post your question there. I get those and I prepare answers for you. However, if you're joining us and haven't either joined our newsletter or our Facebook group yet, then you can join us on live just as Alexander did and add your question, and I will definitely jump in and answer that question to the best of my ability. I can't answer everything, but before we get started, I always like to teach a little something, and today we're going to talk about tenant screening. I want to talk about the things that I recommend to landlords every day. If you've seen videos on my website or my YouTube page that have to do with tenant screening, it's these same procedures that can go overlooked and maybe are dismissed sometimes as unnecessary, but these tips, I'm telling you, these techniques are going to save you money and prevent frustration and hopefully prevent you from ever having to step into a courtroom in the first place with a bad tenant or a bad tenant situation. So let's go ahead and get started right from the start. What kinds of things do I recommend when it comes to tenant screening? Well, the very first thing is you want to have your ideal tenant in mind before you begin, because there is no one tenant that fits all units, right? You might have a high-rise apartment and your rent might be, $4,500. That's not the exact ideal tenant for someone who's in a college town renting individual rooms to college kids. Right, so your tenant looks different in those different situations. And so it's important for you to know the kind of tenant you are aiming for and what kind of criteria they're going to need in order to fit in your particular unit well. And so by having this idea in mind, you're able to essentially set your own limits. And you definitely want to have, well, what do I need in terms of a person's earning capacity? How hesitant am I going to be if I see an eviction on their record from 6 years ago? What about their criminal history? What if I see that they were caught shoplifting and have a conviction for shoplifting, but it was back in 2012? Well, all these things have to be in your consideration because these things come up. The better the screening you do, the more information you have, the more decisions you have to make. And so you don't ever want your decisions to be arbitrary. You don't want to just judge and kind of say, well, I'm going to give this the gut test. You're just asking for, some kind of lawsuit based on discrimination. You want to make sure that you've got an ideal tenant in mind that fits your criteria, and then you want to come up with that criteria. But coming up with it is not enough. You're going to want to share your criteria with the whole world. So when you're posting your rental, you probably also want to be ready to post the screening criteria. What is it going to take to get into this rental? Your prospective tenants should know whether they meet the criteria or not. Now, this helps you in a couple of ways. It's going to ward off any of the looky-loos. And you don't want maybe to open your home up to every interested person if not every interested person measures up to your ideal tenant screening criteria. By having it in place and then advertising, this is what it takes to get in here. In fact, part of your application should be your tenant signing off on this posted criteria and saying, yeah, I've received it, I've reviewed it, and I understand my applicability is subject to this criteria. That's going to help you in a number of ways, not the least of which is, again, sorting through the serious prospective tenants and the not so serious prospective tenants. But it may also be a good CYA because you always want to be able to point to a specific criteria that wasn't met by a prospective tenant that you turned away. Nothing is worse than being accused of some kind of discriminatory practice because you don't have a criteria. You just saw they had a terrible credit history. They had multiple evictions and thought, heck, well, there's no way I'm going to go for that. But you never mentioned that as a basis. And so while in your mind, you might have a perfectly valid basis for rejecting a prospective tenant, an objective viewer might disagree, and somebody might say, maybe there is a claim here for discrimination, and you simply don't want to put yourself in that situation. So come up with your ideal tenant in your mind, have an idea of the kind of tenant you're looking for in terms of screenable criteria, and then post it. Because again, you always want to be on the right side of the law, and you always want to make sure that the things you are focused on are landlord-tenant business decisions, right? You don't want to go based on emotion. You don't want to go based on a hunch. You want to make sure that these are, valid criteria that you can abide by. And if the prospective tenant doesn't meet them, they don't get in. And so, those first two steps. The next step is the actual investigation. And so this is where you need to dig, and whether you have a particular service or you have multiple services, whether you do this kind of investigation on your own, you got to review all of these. Make sure you're reviewing their credit, you're reviewing their criminal history, their employment, and their rental history. Now, I recognize that in certain states, a person's criminal history doesn't come into play. But if you're in a state where you can evaluate criminal history as a basis to reject a potential tenant, then I recommend that you do it. But again, have a line in the sand. What is it going to mean if someone has a whole bunch of traffic violations, but nothing more than that? That's probably not the same as somebody who has, aggravated robbery or, aggravated assault or murder on their criminal history. That's likely going to make a bigger difference to you. But make sure you understand what your limits are with regard to a person's criminal history if your state allows you to do that. When it comes to credit, I mean, there is no absolute magic number that applies in all cases, but a person's credit report can be a telling story about their, credit worthiness and their likelihood of coming through with their debt obligations. Again, none of these, by themselves is going to tell the entire story, which is why you should do all four of them if you can. The employment history is going to talk about their ability to maintain loyalty and to stay put for an extended period of time. If you've got someone who's been with the same employer for 10 years, that's a good sign. It means that they're used to loyalty and sticking with something that works for them. And if that's your unit, you might have somebody in place who you can rely on essentially to pay the balance of your mortgage potentially, which puts you in a great position. Good tenants are there for a long haul and will contribute to you in a way that just goes over and above a normal agreement for rent payment. A good tenant, again, could be the best thing for you, but finding them is difficult. Screening can help you get there, and definitely you want to check for their employment. Now, there's a couple of things that I always talk about to landlords when it comes to employment. It's not enough that you see a W-2. It's not enough that they show you a business card. You have to independently search out this employer and independently find the contact information for the person that they've indicated in their application. If you call up, Mandalay Industries and the phone rings and rings and rings and nobody picks up, you have not properly confirmed their employment yet. If you call and somebody does pick up and they have no idea who you're talking about, that just answered your question. It's a huge red flag for misrepresentation in the application process. Additionally, you want to be able to make sure that in the application process, you're able to confirm with that employer that the individual makes at least the amount that is required. You might have a requirement of 3 times the monthly rent, and you want to make sure with the employer, you don't need to know the exact amount this person earns, but if they're not making at least 3 times, which is what they indicated in their application, then again, red flag, they are misrepresenting their employer and their salary, and both of those just aren't good stories, and are probably red flags that you might use to deny. The last one is their rental history. You definitely want to find out if this individual has been evicted in the past. I don't know how many times I've had landlords come in and after the fact tell me, well, I did a little research. Too little, too late. The fact that you found out that they've been evicted 5 times doesn't help you in the current eviction. It just shows you didn't do your job on the front end. And don't go and tell me, well, my property manager did this or my realtor did this. They're your realtor. They're your property manager. Always know for sure what their screening techniques are and make sure those screening techniques actually measure up. You want to make sure you're getting the most bang for your buck. The fact that they looked at a W-2 isn't enough. Are they going deeper? Are they checking that employer? Are they confirming rental history and checking all available data that is out there? Now, different online services are going to offer different perks. Definitely, I would consult with other landlords as to the kinds of tools they use. Along with tenant management software, you have tenant screening software that is out there online that is pretty good. If you've got somebody that you use or a company that you've used successfully in the past, add it into the comments so that people know and that people are able to see and benefit from the things that you've had work for you when it comes to tenant screening. So you want to have the ideal tenant in mind right from the start. You want to make sure that you are disclosing what your criteria is for that ideal tenant. And then you want to make sure that you're checking rental history, employment history, criminal history, and their credit. And the very last thing that I always recommend to landlords is don't ignore your spidey sense. Okay, there's a couple of things. Sometimes you're going to get a prospective tenant that you never meet. You're going to get a prospective tenant, and they always send their sister to go pick up the keys, or they send their sister to, leave the deposit in the first month's check, or they send their sister with a signed copy of the lease. You should insist on meeting that prospective tenant, because sometimes that's not a sister, it's a switcheroo. It's the actual person who's going to stay there because they've got terrible credit, or they've got a terrible criminal history, or terrible work history, or, they've been evicted 17 times. And so you don't want to ignore that spidey sense. It's like, well, why can't I actually see this individual who allegedly I've been communicating with this whole time? That should tip you off that there might be something weird going on. Another easy one, I made a whole video on fake IDs, is you want to make sure that the ID that you see is the real one. Don't just rely on a digital copy. My 17-year-old daughter can make a great looking fake in under an hour. I know this because she did it for me. I asked her to take a state of Texas ID and make a fake, make it look as real as possible. And she did it, and it only took her, again, less than an hour to do. If you're relying purely on a digital copy, I'm telling you, it's an easy way to be taken advantage of. But if you are requiring that your prospective tenants always share an actual copy, the genuine article, then you can make a decision based on better facts. So all of these things together should make for your screening process to go smoother and to weed out all these potential applicants who just don't measure up. By always having a great screening criteria, you're going to do yourself a lot of favors and put yourself in a position for success. So I hope you found that extremely helpful. I want to go ahead and get into the chat here. We've got a few messages here. Alexander Valentine writes, if a judgment states that the tenant must vacate by 12 noon on January 25th, 2026, with no further delays, property must be returned clean and empty, the monetary amounts are dismissed without prejudice, what happens if the tenant does not move out or comply with the court's instructions? Well, I've never known an order to be this specific. Typically, what a judgment says isn't that a tenant has to move. Instead, what it says is that the court has awarded possession and that a writ of possession cannot be obtained by the plaintiff until date X. And that's right when the doors open, that morning on that date. And so it's not usually when the tenant has to leave. It's, is the tenant still there? If so, you can get a writ of possession on this date or shortly thereafter. Default in Texas, you've got 60 days to get that writ. Don't wait. But you do have to wait until the first available date that's usually featured in the judgment. And so that's normally how that works. And so if the tenant fails to move out, then you should be eligible for a writ. And then you go through the writ process. In Harris County, where I practice, the writ process is usually about 2 to 3 weeks. You pay for the writ, the court processes it, the constables get it. One constable goes and posts it on the door. Sometimes they talk to the tenants, and then another constable will come and actually execute that writ. And that whole timetable is about 2 to 3 weeks in actual practice. Okay. Belinda Williams, good afternoon. Good afternoon, Belinda. I've got one of your questions and I'm ready to answer it. Thank you for joining us. Texas Made, I caught a live finally. All right. Well, I'm glad you did. Happy to have you here, Texas Made. Can you evict a tenant, he asks, or she. Can you evict a tenant in Texas before the 30 days if the situation is severe? If by evict you mean file for eviction, yeah, you can definitely file within 30 days. It depends on your facts, and I don't exactly know what your lease says. Severity alone isn't enough. By default, a notice to vacate in Texas can be for 3 days. Now, presently, we have to contend with the CARES Act, which if you have federal funding that you're receiving, or you're getting federal funding for like federally subsidized rent, or you have a federally backed mortgage, you might be subject to a 30-day notice to vacate based on the remnants of the CARES Act. All of that comes to an end, by the way, at the end of this month. We're in December of 2025. By January 1st of 26, the CARES Act no longer applies and pretty much no longer affects the timetable for an eviction. But assuming that doesn't apply here, yeah, you can potentially send a 3-day notice to vacate. And if they don't leave, you can file a petition for eviction and then get set for trial. Now, another thing that's coming in January of 2026 in the state of Texas is evictions are supposed to get much faster. I just produced a video on that talk about how evictions from start to finish should not go from filing to trial more than 21 days. And so that's the ideal, that's the hope, and we hope that the courts are going to comply with that new order or that new rule in the property code. But yeah, is it possible that somebody gets out in 30 days? Yeah. Usually what we tell clients that on average, tenants get out within 30 to 45 days. We might need to get to judgment. We might need to get a writ of possession. But in many instances, the tenants simply voluntarily leave before we ever have to force them out. It might take the filing of an eviction, but they don't wait for the judgment to be executed against them in most cases. Now, some do, and about 20% of them file an appeal to extend the process a little bit longer, which is why we can't guarantee that they'll be out in 45 days. But on average, it's 30 to 45 days. With an appeal, it could technically double. With other strange things, and some strange things happen, including the filing of a bankruptcy, or the request for a jury trial, or some kind of emergency illness. I've seen all of that. These things can lead to delay, but for the most part, it's about 30 to 45 days longer if there is an appeal. All right. Tyrant I5V. After January 1st, is a 30-day notice still required for Section 8 tenants? No, it is not. You can go with a 3-day notice because the rules have changed with regard to the CARES Act, and that 30-day notice for subsidized tenants no longer applicable starting January 1st in the state of Texas, 2026. All right, Texas Mate says, thank God, LOL. Due to the complaints of illegal activity. Yeah, illegal activity is just like any other violation. Unfortunately, it doesn't speed things up. You know, sometimes landlords come to me and they say, well, what if I waive the rent? Is that going to speed things up? If the court sees I don't even want rent, nope, it absolutely doesn't. In fact, it usually makes things worse because you want to get a judgment for unpaid rent if you can. So I never recommend waiving rent. And so, because it doesn't change it, you don't get on a different eviction track based on the reason for your eviction. So, okay, well, let us proceed and go on to our questions. Like I said, for those of you who submitted questions ahead of time, I'm going to go ahead and get to each of those. For those of you who were unable to do that and still have questions, just like these guys, you can go ahead and submit those questions in the chat, and I will get responses to you in just a bit. In the meantime, I've got numerous questions here, and I'd like to share the first one with you. All right. To maintain privacy and anonymity, is it acceptable for a self-managing landlord to sign and execute a lease using their business name registered as a DBA, even in the fields that ask for the landlord or authorized representative's name and signature? Okay, well, again, I don't exactly know what your lease says about all this, but yeah, you can always use a DBA. The problem is in Texas for sure, and in other states, if the tenant demands, in accordance with the Texas Property Code, to know who the owner of the property is, you know, you're required to disclose that with him. Otherwise, they could unilaterally, in the middle of the lease, just terminate the lease and kind of leave you high and dry. And so if you have the need for anonymity, there's a couple of ways of doing this. So one, you can have the property owned by a holding company, and then you can have the property managed by a separate company that has an agreement with the holding company to sign leases in their name and to file lawsuits in their name for the benefit of the actual owner. That would create some anonymity, but in the lease, you probably have to disclose yourself as a member or an employee, at least, certainly a representative of either the management company or the ownership company. Now, you don't have to, it doesn't have to be that convoluted, but the other way to do it is to have an employee who is a non-owner and a non-member that really just works for your management company or the entity that owns the property, and that employee can sign as a representative of either the owner or the management company, and it's not you. Now, you talked about self-managing landlords. So you can always say, look, I represent this company. But by naming that company, the tenant isn't always on notice that it's your company. But again, this is all public data. And so because it's public and because they are entitled to this information, I don't know how valuable the anonymity element is. And so you can create a few layers for sure. And the average tenant isn't going to do a whole lot of investigating, but understand that it is possible to find you out. And so you just want to make sure that you are disclosing the proper parties in your lease and you feature the proper parties in any subsequent lawsuit for sure, because you don't want to put yourself at a disadvantage having mishandled that part of your lease. So, okay. Second question. This is from Belinda. I know she's watching, or she was earlier. I have a question regarding the tenant using his Chapter 35 VA benefits to pay his housing. When the government shut down, he missed 3 payments. Now that the government is open, he said they told him he'd be getting the back pay on December 1st. That didn't happen. I keep asking him for documentation from the VA stating when he would get his money. He has not provided it. Can I issue a 3-day notice to vacate? Yes, you can. Probably. Now, it doesn't sound like you're getting government subsidized rent. Now, there's a difference. If you're getting paid directly by the government, you are subject to the CARES Act. I don't know if your house has a federally backed loan that for the next few days anyway, would make you subject to a 30-day notice to vacate. So I can't answer that question, but assuming you're not otherwise getting subsidized rent payments, and assuming that you're not functioning based on a federally backed loan, then yeah, you should be able to send a 3-day notice to vacate. The fact that he receives VA benefits and that's the source of his income doesn't in any way otherwise obligate you to this particular tenant. Non-payment is non-payment. I think you've been reasonable in this respect. It's possible that he did receive money, but even if he didn't, it would be akin to someone losing their job and that being the reason that they can't pay the rent. If you have a rent balance that remains unpaid and you have been reasonable, then it makes a lot of sense to move forward with the notice to vacate. My recommendation is 7 days. If you've gone more than 7 days, you've probably gone a little bit too far, and you risk being unable to collect any of it. So yes, at this point, I think 3 payments, that's a pretty substantial amount. You should move forward with notice and then proceed to eviction if at that point payment still has not been received. Now, if during the eviction process, the ship comes in, he gets a bunch of money and he offers the money, it's up to you whether or not you believe it makes sense to continue the landlord-tenant relationship. Again, that's completely up to you. And based on your experience with this particular tenant, you may decide, yeah, if he pays, I'm happy keeping him on board, but, I just can't let this linger indefinitely when it appears that maybe he's not being completely honest. So you always want to be conscious of that. All right, so Francesca Lombardo writes, the realtor's residential lease agreement states that payment shall be received by the landlord by the due date and late fees apply after the third day. Now, if the payment is by electronic means, i.e. Zelle, online deposit, wire transfer, etc., it may take a few days for the transaction to be reflected in the respective bank accounts. When is the rent to be considered as paid? When the amount is debited on the tenant's account or when it's credited on the landlord's account? That's an interesting question. Remember that if you are electing this electronic deposit, assume that the electronic deposit is kind of like your assistant. And your assistant might take a long time to get from the tenant to you. Right? Maybe they decided to take a break and go on a scenic drive, and it takes them 2 days to come back, or they come back and say, oh, I got your rent right here. Because the moment that your assistant received those funds, you got paid. So it doesn't matter that it takes your assistant some additional time to get the funds. Once those funds are in the control of the assistant, in this case, Zelle, online deposit, or wire transfer, etc., it is considered paid. Now, that's a rebuttable presumption because it is possible that it's a false transaction and something goes wrong and the funds never fully transfer. But you have to presume that upon receipt in this method, it is presumed received for all intents and purposes, even if there's a delay before you get it. And so, no, it's not a matter of when it debits from their account, it's when it posts to yours. And again, not so that you can use it, just so that it's obvious they have placed it in the hands of your assistant, right? And so that's the way you make that determination. It's deemed received. You have a second question that I think is clearer in terms of the example. It says, if the payment was made by personal check, there would be a time gap. Would the payment be received with the actual paper check receipt? What would be your advice as the most efficient way to collect rent and avoid disputes? So for me, have a tenant portal. Have a tenant portal set up that'll track all the payments, that'll give them the option of electronically delivering the payments. They could even put them on, I know for me in my office building, I've got a tenant portal and I just set it to auto pay. I never even process the rent payment. I get the invoices. I make sure that the payment clears every month, but I don't even think about it because I set it on auto pay. And that's one of the helpful things. And so if you're asking me what's the most effective and efficient way of doing it, tenant portal. If you can do that, that's the best way. Because again, once you get that check, what happens if you decide to wait 21 days before you take that check and you deposit it in the bank? That can't be held against the tenant. And so because of that, the moment you get the check, you are considered paid in terms of timeliness. So yes, there would be a gap for sure, because there's a procedure that your assistant, the bank, would have to go through in order to, fully recover those funds. But again, that's not something that's going to be held against your tenant. All right, let's go back over here. So Belinda adds, he pays me directly, and that's what I assumed. Thanks, Ernie. You are very welcome, Belinda. All right, so Jeff 19th says, what if they change the date after they submit payment on the 1st, as their bank did not have funds and transactions from assistant did not process until the 6th? So is it because the check had to go through twice, Jeff? I mean, there might be a procedure, or there might be statements in your lease that require, if the first check went NSF for non-sufficient funds, then you could, for all future payments, demand that everything be made in certified funds. That's definitely a possibility. I'm not sure that I understand the facts They change the date after they submit payment on the 1st. Their bank did not have funds. I mean, they didn't have funds on the date that they tendered the payment, but they eventually had funds. I think I need to know a few more facts. I don't know how that works. I mean, like, did they float a hot check? Remember, that used to be a thing when people were more prone to pay by check. ACH has to validate the account. Are there before they? Oh, I see. So, yeah, I mean, if that's the method you choose, and the ACH was not valid the first time, are you talking about a resubmission, Jeff? Because if it's the initial submission, and it just took them a little longer to process it, I imagine that might have something to do with just the procedure. And I don't know who chose that procedure, whether that's a requirement under your lease or whether that's something that you allowed in writing, or whether that's just the method that the tenant elected. Because that's another important thing. Let's say the tenant decides to put it in the mail. In fact, let's say the tenant put it in the mail 5 days earlier. It's not deemed received until you actually get it, right? And it could be a check that you got to go process and what have you. But the moment you get it, it's received. If it's still going in the mail and gets lost, guess what? That's not on you. It is on the tenant. So if they put something in the mail, even if they did it early and it doesn't get received on time, that can be held against the tenant. So Jeff adds, I heard from the online portal that they made a change on the 3-day after they submitted payment on, they made a change on the 3rd day after they submitted payment on the 1st. I think I would still need to know what this change was. And what do you mean you heard from the online portal? Is there something stated that the bank rejected the ACH? I think I would still have to know more specifically what's going on there before I can really respond. But we do have a couple of other questions. If you got more to add, Jeff, feel free to. I'll jump back on in just a second. Let's go ahead and add question 4 from Robert Grayson. I had a tenant fail to pay rent this month. 3-day notice was sent, but upon a visit to the property, the tenant had vacated. Should I still proceed with an eviction and writ of possession? That's no and no. You can't evict somebody who has moved out. And there's no need to get a writ of possession. You can just take possession if they have in fact moved out. Now, we might need some clarification, Robert, to make sure that I understand these facts. It says, I have no forwarding address and the tenant had just renewed the lease a few months ago. The question is, did they take all their stuff or a substantial amount of their stuff? Or did they abandon some personal property there that might indicate they may or may not still be in possession? This is a thing, and it happens, where they took 90% of their stuff, they couldn't fit it all, and so they're coming back, but you come in and say, well, I guess they moved out. I'm going to change the locks and burn this stuff in the backyard. Well, you might just open yourself up to some kind of litigation, and they're going to claim, oh my gosh, grandmother's $40 million brooch, which was the last thing I was going to take, which makes a whole lot of sense, right? You don't want to open yourself up. You might in your lease have an abandonment provision. In Texas, a very common provision is, look, it looks to me like you've left. You haven't paid rent, so you're in default. And so I believe in my reasonable estimation that you have abandoned the remaining property here and you've abandoned your lease. I'm going to give you 48 hours or 72 hours, something reasonable, depends on what your lease says, to respond to me to come and get the remainder of your stuff. If I receive no response from you, I'm going to assume after that amount of time, I can just dispose of your property in any way I see fit, which is in accordance with the lease agreement that we both signed. And then you get that notice to them. Now, hopefully you've got multiple mechanisms for tendering that notice. And it might be, through email, text, the tenant portal, Hopefully you've got a work email and a personal email. Maybe there's a spouse with a personal email and a work email and text. Maybe you've got some kind of app for communication. Every method possible, you send this notice to them and say, look, you've got a short amount of time to come get this stuff. And if you hear crickets, right, no response whatsoever, then by all means, follow the lease after the time has passed and then clear out the stuff and retake possession. You don't need an eviction and you do not need a writ of possession. That simply isn't necessary once they have surrendered possession or abandoned the unit, giving possession back to you. Jeff, I see your update. The portal notifies you of changes made from the tenant side. I see. So I would say that whatever the final change that activated the payment, that's what we're looking at as the date of delivery. So yeah, if on the tenant side, they made some change that actually made the funds available, that's the date of the payment. All right, so Tyrant I5V. Yes, it's empty. Just want to make sure they couldn't move back in. So again, similar thing, where if they leave and they've left a perfectly empty apartment, yeah, you can come in, take possession, change the locks, you're done. They have surrendered the property at that time, especially if they said, hey, I'm leaving on this date, or they left the keys on the counter, or they told you, hey, I threw the keys in the backyard. All those indicate surrender, and your lease may define surrender in that specific way. But if you're ever in doubt, send that notice of abandonment. That kind of clears things up and patches up any, or ties up any loose ends regarding whether or not they actually did surrender. This is just another layer of protection for you. Belinda Williams 598. You mentioned that if the landlord waits too long, he risks not getting any money. Can you elaborate on this? Yes. If your tenant is in default, this is regarding my question with the VA benefits. Yeah, so you've got somebody who hasn't paid in 3 months. If you wait 6 months before you activate your eviction and still wait, like when's that big refund check coming in? If you keep waiting, it could be that ultimately you get nothing. So not only did you not get paid, but you lost multiple months along the way. And so this is the reason why I always recommend that landlords act quickly, because presumably you're holding on to 1 month of rent in a security deposit. So if it came down to it, you've at least got that. Now that assumes there's no damage to the property, and I hope there isn't, but you want to minimize your losses as much as you can. And so that would require you to act quickly. Now, I know this is a very peculiar situation because of the government shutdown, but I wouldn't wait too much longer. If a ship hasn't come in, it may never come in, and you might need to move on, or you need to force the issue and say, look, this is something you and I are going to have to work out, and whether that means you got to double up your rent in some way to pay back what you owe, we got to address the amount that remains unpaid. Okay, and Tyrant I5V says, thank you, sir. You are welcome. All right, let us continue with the questions. We're on question 5. Terry Han writes, I have 2 questions. So this is 5A and 5B. Can you evict a tenant who still has time remaining on a lease for lease violations? Absolutely, you can. Now, I preach a 3 strikes and you're out, but kind of message to landlords whenever it's just pure lease violation, because sometimes the lease violations are small. And so if you've got, smaller violations, then I wouldn't jump to, for example, they failed to cut the grass this weekend. You don't want to send a notice to vacate for breach of the lease because they failed to cut the grass. Instead, what you want to do is you want to send them a notice of default and say, hey, your lease says you're supposed to cut the grass every other week. I see that you cut it last week, but you haven't cut it, or you cut it last time, but you didn't cut it this time. Please cut it within the next 3 days so that you're no longer in violation. Sure enough, on day 4, you check, they didn't cut it. So you can send a follow-up notice. look, on such and such date, I gave you a notice, you hadn't cut the grass. This is your second notice. Please understand that multiple violations of your lease could result in eviction. I'm going to check in 3 more days. Please make sure the grass is cut. Sure enough, you come back 4 days later and the grass is not cut. You say, look, this is the last notice I'm going to give you. Please make sure the grass is cut. If it is not, I will proceed to send you a notice to vacate and continue with an eviction as needed. And wouldn't you know, 4 days later, you show up, still grass not cut. Now, the reason you want to send these multiple notices for these lease violations is because guess what's going to happen on the day of trial? You send a notice to vacate, they don't move, they still don't cut the grass, you file your eviction. Before trial, they're going to show up with photographs and video and say, Your Honor, we cut the grass. Take a look at this. This is the best looking grass in the country right now. Hands down, I do great work when it comes to grass cutting. And you can tell the judge, yes, that's beautiful, and I appreciate that they did that. However, I'm evicting them not for a single incident, but for multiple incidents of me having to send notice and them time after time after time rejecting my notices. I don't want to have to keep doing this. I warned them before that multiple notices unheeded would result in eviction. I would like possession. Now, that's a much stronger case than if you go with just a single notice. Additionally, if you've got multiple violations, that might amount to enough. But I always suggest to landlords to give the tenant, when it has nothing to do with rent, give the tenant an opportunity to cure. If they can cure, then great, let them do it. There are certain things that really aren't subject to cure. For example, the tenant burned the kitchen trying to, I don't know, fry an egg, and the whole kitchen got burned from their negligence. That might be enough to say, you got to go. You've damaged the property to an excessive amount by your negligence. Or let's say they committed some kind of crime. We're like, well, I'm not going to give you 3 strikes for a meth lab. You were arrested for cooking meth in the house. You got to go right now. So the more egregious the violation, you can probably get by with with the single notice to vacate. But if there's smaller violations that can be cured, give your tenants an opportunity to do that. If they fail, then you might have to resort to an eviction. Now, I want to continue to B. How do you handle a tenant that is unresponsive to your written notices about a lease violation? Keep sending that notice. If they're not responsive, just like I said, you're building a case for the court. This is not for their benefit. Don't be offended if they don't respond. If they're not doing what they are required to do, that's when you 1, 2, 3 strikes, you get them out with a notice to vacate. They still don't move. You file the eviction and you let the court know, look, I was diligent, I was patient. They refused to adhere to the lease. They didn't respond to any of my notices. I can't trust them in the future to follow the terms of the agreement that we both signed. Easy peasy. I hope that was helpful. Okay. So Jeff C. writes, how feasible is it to evict for such a topic, multiple, simple, small, or small violations? Again, it all has to do with just how egregious the violation is and what the tenant did in response to your multiple notices. The number of violations isn't what matters. How many times did you issue written notice of violation? What did you say in your notice? Did you give a time frame for them to cure that violation? So, for example, in this case, if it has to do with late payment, they ultimately paid, maybe even they paid all the late fees, but you tell them, look, that's still a violation. Please make sure next time you pay on time. And they do it again and again and again. You're getting paid, but you're not getting paid in conformity with the lease. And that might be enough after notice for you to say, that's it, we're done. I'm going to go ahead and issue a notice to vacate. Now, not every judge is going to go for that. I'll tell you that judges don't like handing out eviction judgments. But if it's egregious enough or it happens so many times after multiple notices, the judge is bound by the property code, and you are bound by your own lease agreement. And so you have a much higher chance with multiple notices than you do with just one, but it's not a guarantee. So if you want to seal the deal, again, issue multiple notices. For something small, you might need, 4 or 5. You're going to have to, kind of play it by ear depending on what the violation is, because that's another thing. Landlords don't want ticky-tack violations. They also don't want to hear the following. Well, I didn't enforce the lease for the first 20 months, but now here in month 21, by gum, I'm going to enforce it. If you allow the tenant to, by course of performance, violate for 20 months, that term is rendered virtually meaningless. And I know what some of you are going to say. Well, my lease says I have a non-waiver clause, which means even if I waive it 5,000 times, I can enforce my terms at any time. And I know that it's there, but that's not something that's going to hold a lot of weight with the eviction court. Just saying what I've seen over the course of 15 years. Okay. James writes, I had to evict for that reason, burning the kitchen. Sorry, guy. That sounds pretty rough. Jeff C. Particularly if they reject or don't pick up the certified mail. Similarly, they back out into the garage door and refuse to pay to fix because they say it was already old. Thank you. It makes sense. Well, I'm glad. The way you defend yourself against that, that scratch was already there, or that dent was there, or that fire was already here, is before you ever hand over the keys, you have documented the condition of the entire house. Every room, every appliance, the floors, the walls, the ceiling, the roof, not so much, but definitely the yard. What's the condition of the grass before they came in? What are the condition of the shrubs and the flowers? Maybe you have a swimming pool. Maybe you have a shed. You want to adequately document everything. The plumbing, you want to adequately document the things that you just installed. How old is that stove? How old is the microwave? What about the paint that you paid thousands of dollars for in the living room, in the hall? All of that you want to preserve as good a record as you possibly can to be able to show a before and after to a court to demonstrate the damage that they did and prove this exceeds normal use and ordinary wear and tear, Your Honor. This was a condition the house was in at the beginning, and this is what it's in now. It is obvious that this exceeds normal use and ordinary wear and tear. And so that's how you protect yourself the most. James writes, I take pictures and video. I think that's a good idea. You want to create evidence for yourself. You might even email those to yourself. I see people do that. So they email these things to themselves so they can date stamp them. And so whatever you do to preserve these records is always a good idea. Okay, so now we're on to question 6. My tenant moved out. At the end of our lease agreement, the damages exceeded the security deposit by $3,000. If I take him to small claims court and the judge sides with me, can the tenant be forced to pay? The tenant has told me I could sue him as much as I want, but he will never pay me a dime. I don't know if he has a bank account. He always paid by Zelle. Well, chances are it's going to be difficult to collect from somebody who doesn't own exempt property or who doesn't have an account that you can access. But by creating a judgment lien, you could do a couple of things. So first, an individual is protected in Texas in a number of ways. One of those is, you can't take away their homestead. So let's say they buy a house and then you get your judgment, and then you put a judgment lien on them. You can't use that lien to foreclose on that house. But you can establish a judgment lien by obtaining an abstract of that judgment and recording it with the county, particularly the county where that property is located. And the reason you want to do that is because most people don't stay in their houses indefinitely. Most people move within 5 to 7 years. So what's going to happen once he puts his house on the market and he plans to sell it? Guess what is attached at that point? Your judgment lien. And in order to get out from under it, not only does he have to pay off his mortgage, he's going to have to pay off that judgment lien because you've properly attached it to the property, not in any way that you could foreclose while he was living there, again, as his homestead, but once he leaves it, once he sells it, it's no longer his homestead, so he owes you that debt. So that's one way. The other is prior to him buying, a title company is going to see, are you going to do anything to encumber the property that you're attempting to purchase? If so, your lender is probably going to make you clear out any of these judgment liens that you have before they're willing to loan you this money. At that point, if you've properly recorded your lien with an abstract of judgment, you're likely to get a phone call and ultimately get paid the full judgment amount plus interest to release the judgment in this case. So I would recommend it if you know that this individual is likely to buy a house or has multiple vehicles. Because while you are secured with one vehicle titled in your name, two if you're a married couple, anything beyond that is subject potentially to seizure. And if you could seize that and sell it at a constable sale, you could essentially recover some, if not all, of your judgment debt. So you do have certain avenues, and once a writ of execution, which is what it's called after you abstract it, is filed and served on them, the constables can look up information that is recorded with the county, registered vehicles, registered real property, and see if any of it is subject to seizure and ultimately a constable sale. So if you need help with that, come see an attorney. We're happy to investigate those claims whenever you've got them. All right, here we go. The very last question. I have an ATM. This is an interesting one. I have an ATM in a building that was rented out to a game room. The game room owner moved out of the building and didn't let me know. Now, the owner of the building is not letting me come get my ATM without paying her for her time to come let me in. Minimum of $150 to the building, $150 her travel back, and $150 for the time I'm there, which will be 15 minutes. Is this legal? That she can hold my ATM and make me pay to get it out of her building? Probably not. So in many commercial leases, the landlord can impose a lien on the personal, mostly the business personal property of the tenant. But in this case, the ATM doesn't belong to the tenant. It belongs to a third party who didn't agree to any terms with this particular landlord. Title to that ATM, I'm assuming, can be proven to be in you, Ms. Branscombe. And so as long as you can demonstrate ownership, the landlord can't say that you agreed in any way or obligated yourself in any way to her for her time or the rate that she's claiming. If that were the case, why doesn't she just charge you $15,000 for her time or $15 million? It doesn't seem like it is reasonable. You may have to contact a constable and say, look, I'm going there to pick up my property. It was held by a former tenant who has abandoned the place, but I own this ATM. The landlord is not allowing me to recover my property. And so you should be allowed to, reasonable access to recover property that belongs to you. I'm not exactly sure what went on. It doesn't sound like you are under any obligation with regard to this landlord. Could the tenant be charged these fees? That sounds more reasonable, that these fees could be assessed against the tenant, but they shouldn't be assessed against you, a neutral third party. And so I hope that helps with that question, and I hope you are able to more easily recover your ATM. So, landlords, I appreciate those of you who stuck around all the way to the end. For those of you watching the replay, I do want you to know that we've got one last YouTube Live for the year. It'll be next week, December 17th, because on the 24th and on the 31st, we will have no YouTube Live. We will be back in January, but the last 2 Wednesdays of the week, we're going to take a break. And so our last YouTube Live for the year 2025 will be next Wednesday, 4 o'clock. I look forward to seeing you there. Our topic will be, what kind of limits can I place on in a lease regarding pets? So I'll tell you what I counsel landlords with regard to this particular issue next week. I look forward to those of you who can join being around. But until next time, landlords, happy leasing.